Affirmative action. Equal opportunity employment measures that federal contractors and subcontractors are legally required to adopt. These measures are intended to prevent discrimination against employees or applicants for employment on the basis of color, religion, sex, or national origin.
The facts. The Medical School of UC Davis opened in 1968 with a class of 50 students. The size was increased to 100 in 1971. There were no special applicants programs when the school opened, and the amount of minorities attending the medical school was very low. Only 3 Asian students were admitted, and no other students of minority backgrounds. Over the next 2 years, a special admissions program was created to increase the amount of disadvantaged students represented in the class. Alan Bakke had joined the Marines in 1967 and served several months in Vietnam before being honorably discharged. He then went to work for NASA as an engineer. In 1973, having taken an interest in medicine while serving overseas, the 33-year-old white male applied to 12 different medical schools, including the UC Davis Medical School. He was denied to several schools, Davis included, and several schools expressed worry about his age, despite his status as a very desirable medical student and high test scores. He applied to Davis, but was denied a second time in 1974, despite Davis's special applicants program admitting minority applicants with lower test scores and GPAs than Bakke. After his second rejection, Bakke filed an action in state court for mandatory injunctive and declaratory relief to compel his admission to Davis, alleging that the special admissions program operated to exclude him on the basis of race in violation of the Equal Protection Clause of the 14th Amendment.
The constitutional principle in question. The main issue within each case was the constitutionality of affirmative action and whether or not it's legal under the Equal Protection Clause of the 14th Amendment. This clause says that no state shall deny any person in its jurisdiction the equal protection of the law.
The decision. The decision for the regents of the UC versus Bakke case. The court found the admission process for UC Davis unconstitutional because it set aside 100 seats available for blacks, Chicanos, Asians, and American Indians, and it established a separate process for those 16 spaces. The court ruled that it could not ex ante set aside seats specifically for a certain race, resulting in an automatic exclusion of others based only on race. Other similar cases to this would be a Fisher versus the University of Texas, where the university denied her access because she was white. The decision is to be found in the spring.
The rationale. The court reasoned that they needed diversity in the classroom. It would increase the amount of minorities in medical schools and the medical profession. It would counter discrimination. It would increase the amount of physicians in areas that are underserved, and you would obtain the educational benefits that come with the ethnic minority or diversity. The court also reasoned that you could consider race a plus factor in the admissions process. This would not rely on the Equal Protection Clause of the 14th Amendment, but on the Title VI of the Civil Rights Act. The 14th Amendment states that Equal Protection Clause requires each state to provide equal protection to all people within its jurisdiction. The Civil Rights Act prohibits discrimination on the basis of race, color, and national origin in programs and activities receiving federal financial assistance.
The facts. The University of Michigan Law School follows an official admissions policy that seeks to achieve student body diversity through compliance with Regents of the University of California versus Bakke. The school is among the nation's top law schools, with about 3,500 people applying for the class of 350. In 1992, the school charged a faculty with drafting an admissions policy that would achieve the school's goals of excellence and racial diversity. In accordance with the rulings of Regents of UC versus Bakke, the policy requires that admissions be based on much more than grades and test scores. The highest test scores and GPA do not guarantee admissions, and low scores do not automatically disqualify an applicant. Lee Bollinger is the president of the University of Michigan and former dean of the law school. Barbara Grutter's application to the University of Michigan Law School was denied in 1997 after she initially applied in 1993 and was placed on a waiting list. A white female resident of Michigan, she claimed that the law school denied her application in favor of minority students, violating the 14th Amendment. In December 1997, she filed a lawsuit against the school and district court of Eastern Michigan. Grutter alleged that the school had discriminated against her based on her race. She claimed the school's admission process was based predominantly on race, and minority groups were given a significantly greater chance of admission.
The constitutional principle in question. The main issue within each case was the constitutionality of affirmative action and whether or not it's legal under the Equal Protection Clause of the 14th Amendment. This clause says that no state shall deny any person in its jurisdiction the equal protection of the law.
The decision. In the Grutter v. Bellinger case, the Supreme Court ruled in a 5-4 decision that race can be used as one of the several factors in school admission without violating the Equal Protection Clause of the 14th Amendment. The court found that the University of Michigan Law School's narrowly tailored policy, which considered race and other factors, was constitutional and appropriate. After Gretz and Gutter in November of 2006, voters in Michigan approved Prop 2, which bans public affirmative action programs that gave preferential treatment to groups or individuals based on their gender, race, color, etc. for public employment and public education.
The rationale. The decision upheld the position asserted in Justin Powell's concurrence in Regents of the University of California versus Bakke. In the case of United States versus Virginia, the court required the Virginia Military Institute to radically reshape its admissions program and the character of the institution to accept all races. Proposition 209 barred Berkeley law from granting preferential treatment on the basis of race. Proposition 209 is a California proposition, and it prohibits state government institutions from considering race, sex, or ethnicity, specifically in the areas of public employment, public contracting, and public education.
The facts. Petitioners Jennifer Gratz and Patrick Homaker, both white Michigan residents, applied to the University of Michigan's College of Literature, Science, and Arts in 1995 and 1997, respectively. Though Gratz was considered well qualified for the school and Homaker was considered to be within qualified range, both were denied early admission and ultimately denied admission altogether. The two filed the suit in district court, claiming that the school was discriminating against them based on race, violating the 14th Amendment.
The constitutional principle in question. The main issue within each case was the constitutionality of affirmative action and whether or not it's legal under the Equal Protection Clause of the 14th Amendment. This clause says that no state shall deny any person in its jurisdiction the equal protection of the law.
The decision. In a 6-3 decision on the court case of Gratz v. Bellinger, the U.S. Supreme Court ruled that the University of Michigan's undergraduate admission system was unconstitutional because it was too mechanical and does not appear to consider the individual's actual contribution to the educational environment.
The rationale. This violates both the Equal Protection Clause and Title VI. 20 automatic points were awarded to unrepresented minorities and did not provide the individualized consideration that the other races did. Justice Rehnquist said, because of the university's use of race in its current freshman admissions policy is not narrowly tailored to achieve respondents' asserted compelling interest in diversity, the admission policy violates the Equal Protection Clause.